Islam, unlike, say, certain types of Christianity, has offered often quite detailed framework for the conduct of society. And it's here that Islamic law, or what we call Islamic law, has to be discussed. Now, clearly the Quran itself contains laws. I've already briefly alluded to the need to deconstruct this usual stereotype of Islam as a kind of Arab version of rabbinical Judaism, by which these traditional European anti-Semitic concepts are applied conveniently to put down the new religion. In fact, the Quran contains no more than 60 or 70 verses out of the total of maybe 100 times that, which can explicitly and immediately be slotted into a legal code. Other verses are either not giving prescriptions or prohibitions, or they're dealing in terms of generalities that need to be fleshed out by the Sunnah or by the lawyers. Nonetheless, the Quran is the fundamental source of law. And law here we're using in a very vague and broad sense to indicate preferences and norms, as well as frontiers of human behavior that might have to carry legal sanction if they're transgressed. By instituting formal laws, as we've already seen when I talked about the paradox of Islam's achievement, the Quran and the Prophet who interpreted it and actualized it were departing very radically from existing Arabian practice. As we saw previously, there had been no overarching legislative authority or judicial material. Enforcement of the law was generally the responsibility of the private individual who'd suffered an injury. Disputes between tribes were resolved by warfare. Disputes within the tribe would be settled by arbitration by some mutually agreed individual. So the Quran erupts into this world with a very unfamiliar agenda. True, it does uphold the validity in purified form of certain pre-Islamic customs, but very many others it overturns. And it helps when we consider Islamic law to realize how radical its agenda was in its original world. Obviously, the prohibitions on alcohol and on usury must, however you read the sources, have been profoundly surprising to the Prophet's contemporaries, some of the earliest rules of the religion, and clearly they were not easy to enforce. Even more surprising and fundamental was the Prophet's establishment of a permanent judicial system that dished out justice along strictly non-tribal lines. We find after the hijrah from Mecca to Medina, when the community becomes a community with a political dimension for the first time, and hence can meaningfully begin to order itself as a law-abiding community, we find revelations begin to come that supply basic guidance on some of the key moral and also administrative questions that were being faced by this radically new type of Arabian community. For instance, in Medina, the flesh of swine is prohibited. A range of other dietary principles are introduced which seem to recall Jewish dietary law, although in greatly simplified form. Between parentheses here, it may be useful to know that obviously the prohibition on swine is universally recognized by Muslims. The question of meat slaughtered by non-Muslims is a perennial question of interest for Muslims, particularly living in immigrant communities in this part of the world. The classical jurists aver that meat that is slaughtered by the people of the book, usually interpreted as meaning Jews and Christians, sometimes the category is expanded to include other religionists as well, is permissible for Muslim consumption. The controversy nowadays arises because we no longer live in unproblematically Christian societies. So the local example is the community at Dar al-Islam, which is very happy to eat lamb and beef that's slaughtered by the local devoutly Catholic Mexican population. But as soon as you go to a big city and you don't really know where the meat is coming from, or if it's been slaughtered by someone who might be a communist or an atheist or whatever, then moral difficulties arise. And very many Muslims, not so much in the United States, perhaps because religion is stronger here, but certainly in England, will only eat meat that is halal, vaguely equivalent, I suppose, to the Jewish kosher, as in terms of the meaning of the word. It just means lawful. So that was one set of rules that was established in Medina. Quranic verses that unproblematically outlawed the consumption of the flesh of swine and certain other categories. Carrion, for instance. If a Muslim finds an animal that's been killed on the road, he or she can't eat it. It has to be killed by a human agent. Similarly, meat that has been slaughtered to pagan deities. Also in Medina we find some of the earliest legislation of Islam are the rules that are issued for the division of war spoils. But perhaps the most radical change which we find these texts inaugurating in Arabian society concern the status of women. And I know that you're promised a separate lecture on gender. But for our purposes it's worth recalling that before Islam, marriage was really conceived as being a version of a sale, with the bride's father receiving the payment of his choice from the groom. This was how things were usually arranged. And the Quran overturns this by stipulating that while a sum of money is still payable, this is the so-called sadaq, sometimes wrongly translated as dowry or even sometimes as bride price. So this sum of money is still payable, it goes to the bride and not to her father, and it becomes her inalienable property once the marriage is consummated. This is laid down in the Quran, Surah 4, verse 4. What this meant was that for the first time a woman now became a contracting party and not just the passive object of a sale. Another significant change instituted by these sprinkling of legislative verses in the Quran was the law on divorce, the other end of marriage. Pre-Islamic custom had given the husband the right to divorce his wife at a moment's notice. And the Quran stipulates that a divorce will only become effective following a 3-month kind of cooling off period or after the birth of a child if she happens to be pregnant. The purpose here seems to have been both to establish unambiguously the paternity of any child born following the end of the marriage, and also it seems to provide an opportunity for reconciliation. So one of the significant things that is happening to the new religious community in Medina is that it's getting laws for the first time, and in almost every case these laws are very surprising and new. Inheritance law was also of concern to the Quran. In fact, it's one of the most detailed areas of Quranic legislation. In Arabia, immediately before the arrival of Islam, a patrilineal system seems to have prevailed. It's sometimes held, I think quite reasonably, that if we go further back in Arabian history we can discern the outlines of a matrilineal system, but certainly the Quran's immediate context was a patrilineal one. And in that world, property generally could only be inherited by male heirs, the idea being that this would preclude the passage of wealth to women who might then marry outside the tribe or be captured and produce children outside the tribe. And the Quran, of course, was seeking to replace the tribe with a new social unit, the Ummah, the maternal community of believers, as the essential legal unit. And also, of course, as we saw with marriage, to establish women as separate legal entities. Woman has her own judicial personality in Islamic law, for instance, unlike even English law until about 100 years ago, when it was assumed that upon marriage a woman's personality and legal identity would be subsumed under that of her husband. In Islamic law that's never been the case, and a woman always retains complete financial control over her affairs. So we find established Arabian usage overturned again by a radical series of Quranic verses which lay down detailed provision for estate division. And this gives not only fathers, brothers and sons a share, but also wives, mothers, daughters and sisters. The proviso, however, is attached that the male share is to be twice that of the female. This is an apparent inequality which is hotly debated in the modern Islamic world, and the traditional explanation is that in a traditional society men have more financial responsibilities than women, and therefore this is not unjust. Another law that is clearly Quranic is the law on homicide. Before Islam, murders had almost invariably been resolved simply by revenge attacks from members of the victim's tribe. Frequently this would precipitate vendettas which could drag on for generations. The Quran, however, adopts the biblical maxim of an eye for an eye, a tooth for a tooth, and the punishment, and this was really the critical reform, not to be carried out by the victim's family, but by the state, by the Muslim state. However, we do find a relic of the tribal system surviving in the Quranic acknowledgement, and here you have a radical departure from most forms of Western law, of the right of the next of kin to have the death penalty commuted to a lesser punishment. This is in Quran, Surah 17, verse 33. Do not take the life which God has made sacrosanct, save in accordance with justice. And if a person is slain unjustly, we have granted a power or an authority to his heir. Maybe some of you read of the quite recent case in Saudi Arabia, whereby in an Islamic court, or what passes for such things in Saudi Arabia, 2 British nurses were convicted of murdering one of their colleagues, an Australian colleague. And the Saudis, following this Quranic provision, duly sentenced the 2 women to death. But they then contacted the victim's family to offer them this Quranic right to decide that the death penalty could be waived in favor of a prison sentence. And it was, for many weeks, sort of macabre fascination in the British press that actually the Australian next of kin, I think he was the brother of the nurse who'd been killed, refused to avail himself of this facility and insisted that the death penalty be carried out. This was very much to the embarrassment of the Saudis, who constantly wished to improve their image in the West. And the matter was only resolved when finally the brother caved in and agreed to accept unspecified financial compensation. The Quran and subsequent Islamic law do not specify a method of execution, stipulating only that it has to be rapid. So these are a few key areas in which the Quran clearly is acting as a source of legislation. However, as we've seen, it's really only in a few areas, and specifically these areas, probably because these are the areas which the lawgiver wished to make most unambiguous, because these are some of the most radical changes that were being effected in Arabian society, and for that reason they had to be specified in black and white in the most sacred text itself. But clearly these rules on their own are not enough to regulate an entire society, and this is where the hadith literature steps in. Properly understood, the hadith literature is not some kind of series of afterthoughts to the Quran or a series of footnotes to it, but is a solid, independent tradition of revelation in its own right, laying down principles and details of substantive law on areas in which the Quran is not only insufficiently detailed, but may be completely silent. In the Quran, for instance, we find this generalized injunction to give the zakat, the poor due. But it's only in the hadith that we can discover how this principle is actually to be activated as the basis of a viable system of charity or taxation. And the Prophet's legislation was also necessary to render operative Quranic prescriptions that seemed, as they stood, to be incomplete. For example, the new inheritance law, which we've just looked at, specified that some of a deceased person's assets could be distributed by testamentary disposition to anyone he wished, in other words, by making the equivalent of a will, before the set formula of estate division is applied. A wife getting 50%, a surviving father getting 25%, or whatever it was, and the rules are very complicated. But it doesn't say what exactly these percentages are. However, so for this reason, that verse, although it's very detailed in the Quran, isn't actually susceptible of immediate application as a principle of law. So here the Sunnah steps in, and the Prophet specifies that the proportion is to be 1/3. In other words, you can dish out your wealth to the extent of 1/3, and after that, these set proportions have to be applied. Similarly, no bequest can be made in favor of a relation who is already an heir. So those are some examples, and if I gave you more than a fraction of an indication of how ramifying and complex the system is, we would be here all night.